Your Honor, the petitioner has presented three theories by which the court should hold Mr. Minton in contempt. The first theory is that somehow Mr. Minton violated one or more of the prohibitions of the court's second temporary injunction. And we've recited those ad nauseum, but by that I mean coming within 10 feet of a church member, blocking the path of a church member or vehicle, physically inhibiting any person from leaving or entering the building, committing acts of harassment or violence against a member of the church, and demonstrating in a non-orange zone. Now, there are two remaining theories, but they do not comport with the charging document here, because again, the orders to show cause specifically referred to violations of the injunction. They did not refer to violations of the law or acts that otherwise exemplified contempt of the court. However, addressing those two theories, they suggest that there is an indirect criminal contempt of the court using Thompson v. State at 398 Southern 2nd 514, and that this constituted an obstruction of the court's proper functioning. I would point out that Thompson, first of all, is not on point because it involved a contempt of court by a lawyer failing to appear for a trial calendar. I would also point out that the court found that there was a complete lack of intent in that case, and the conviction for contempt was reversed. I'm also concerned that the church has any standing to raise this issue when their motion for an order to show cause clearly referred only to violations of the court's temporary second injunction. Be that as it may, I would point out to the court that if the court wishes to proceed on that theory and reviewing the evidence, that Thompson does state that intent is an essential element of contempt, and that intent must be proved beyond and to the exclusion of every reasonable doubt before there can be a finding of contempt. The third theory presented by the petitioner, a theory that we again reject on very solid legal grounds, is that these constituted criminal acts which violated specific statutes. The criminal law cannot and does not define these offenses, and the law in Florida for at least the last 46 years has been that an injunction cannot be used to enjoin the commission of a crime or to enforce criminal laws. And I've cited Weiner v. Kelly, 82 Southern 2nd 155 on that point. The court, of course, is fully aware that the proof must be beyond and to the exclusion of every reasonable doubt, and that the reasonable doubt can be established by the evidence, conflicts in the evidence, or lack of evidence. The conflicts in this evidence and the lack of evidence, combined with lack of legal basis, clearly show that Mr. Minton is not guilty of contempt of any violation of the injunction and should not be subjected to a finding of criminal contempt. Now, talking about the specific instances, the spy camera incident on December 4th, in anticipation of Mr. Merritt's own arguments, I would adopt those arguments as well. But let's talk about the basis by which they came to be there. Mr. Minton was there photographing this spy camera for a legitimate purpose. It was to serve as the basis of a motion or other remedy in an independent action. It has been typified as a self-help measure. It was no more self-help than a person taking pictures of an automobile accident. Mr. Minton had the right to be where he was, and he had the right to do what he was doing. They have cited absolutely no basis under which this was a violation of the injunction. The closest possible tenuous argument, stretching it to the limit, is that somehow this constituted a harassment of a Church of Scientology member. There was absolutely no competent evidence presented to this court that any member of the Church of Scientology was harassed by this action. I would also point out that Mr. Minton's actions were done appropriately and with due care. There is no competent evidence presented to the court that the camera was broken or that the focus was even hurt. The only work that we know of that they performed on this camera and the junction box contained in it was to quickly move the camera from the rat bait building to the side of the Clearwater Bank building for the benefit of the self-serving exhibit number 7, showing that the camera was now against the Clearwater Bank building. This action by Mr. Minton did not constitute a picketing or demonstration by any stretch of the imagination. He did not block or interfere with anyone. The bread delivery breezed right through. Again, I remind the court that the bread delivery was the only allegation in the motion to show cause or the order to show cause in which it was alleged that Mr. Minton blocked or interfered with anybody going into or out of the building. And it is clear that the bread delivery went through. On the issue of inhibiting someone from exiting the building, I think it is significant that during the petitioner's case in chief, they never presented any evidence whatsoever that anybody was inhibited from entering or leaving the building. Subsequently, on rebuttal, and I think the court will certainly consider that it was first presented on rebuttal, the only evidence we have on this point is from Barbara Winberg, who was improperly presented as a rebuttal witness when it should have been presented in the case in chief. Apart from the fact that her testimony has absolutely nothing to do with any of the allegations in the order to show cause, she testified that, in fact, she was inhibited from exiting the building. There are two credibility problems with her testimony. She claims to have told no one about this at all until her conversation with the attorneys for the first time on Sunday, February 18th, the day before her testimony. Now, there's a definite credibility problem as to how this testimony suddenly emerged full-blown and conveniently in time for it to serve as some form of rebuttal evidence. We are not told how she was located, how her testimony came to light. There is no corroboration for her complaint. There is no background provided by the petitioner as to why we should believe Ms. Winberg. But then there's credibility problem number 2, and is far more substantive. Her version of what occurred that day while Mr. Minton was actually on the ladder does not comport with either the known facts or the physical evidence presented to the court by way of the videotape of the December 4th camera incident. The videotape, quite frankly, does not support her version. The court heard her testimony. She testified that she came out of the right-hand door of the double door, that she opened that door fully, that she stepped 1 to 2 feet out of that door, and that when she saw Mr. Minton, his back was turned to her on the ladder. However, she was able to identify him because he was in profile to her. She further states that she viewed this for 1 to 2 seconds, felt inhibited, and went back into the building. I invite the court to view the video, and I believe Mr. Merritt may in fact present that to the court as part of his argument, and I won't steal Mr. Merritt's thunder on that point. But I can't let it pass without pointing out that during the entire time Mr. Minton is on the ladder, we do not see the door open for anything other than the bread delivery. There is a point at which the court will observe that Mr. Minton, with the assistance of Jesse Prince, moves the ladder 2 feet further south in order to get a different angle. At that point, and only at that point, is his back turned toward the double door, when Ms. Winberg claims she came out of the door. Observe it closely and you will see that the videotape fully shows the right-hand side door, and not once does that door open a crack. It certainly doesn't open fully, and Ms. Winberg doesn't appear on the videotape at all, emerging 1 to 2 feet out of that door, looking at Mr. Minton, and then retreating back in because she's inhibited. That videotape clearly shows fabrication on the part of this witness. And whatever the court may do with this particular incident, it should not base its decision on any testimony presented by this witness where her testimony is not only not corroborated, it is in fact belied by the videotape evidence which the court has. There is no indication during this entire incident that Mr. Minton came within 10 feet of any member of the Church of Scientology. He clearly has indicated there was no intent to commit a violation of the word of the, or the spirit of the injunction when he took pictures of the camera. He did not see anyone within 10 feet of him, and by Ms. Winberg's own testimony, if we were to accord it the credibility it does not deserve, Mr. Minton did not appear to see her because he was too busy taking pictures, and therefore he could not have even known of her presence. There is no independent proof of a separate intent to violate this court injunction during this entire episode. There was no violation of any of the 5 prohibitions in the injunction, nor was it otherwise any form of direct criminal contempt. Next, concerning the process server incident on January 5th, we have maintained this is not a violation of the injunction. Clearly, Lindsay Colton, the private investigator, was not a member of the Church of Scientology. So right there, that eliminates certain violations of the injunction. He did not come within 10 feet of a member of the church. He did not harass or do violence to a member of the church. He did not block entrance or egress from any church property. The only issues that remain, well, there's demonstration. He certainly wasn't demonstrating right in front of the Lisa McPherson Trust Building. And because it happened right in front of the Lisa McPherson Trust Building, there is no violation of the word or the purpose of the injunction. The petitioner's entire focus here appears to be on the court's order of December 1st that clarifies the injunction. Now, what does that order say as to process servers? It simply says that process servers are not subject to this injunction. That if the church or the Lisa McPherson Trust hires a process server, that process server is allowed to come within 10 feet of someone to serve papers. Consider, going back to December of last year, consider what the court's purpose was in clarifying the injunction. Consider also, by the way, that this motion for clarification was not actually subject to a hearing by the court, but was granted essentially ex parte based on the court's own feeling concerning what was necessary to clarify. And it is clear, at least I presume that it's clear, what the court's intent was as to process servers. And that was that there would be times when the church would wish to serve a copy of an injunction upon people in the orange zone, people who might be associated with the Lisa McPherson Trust, and it would not be a violation for them to be approached by a process server and handed a copy of the injunction. Now, the court did not say in its motion for clarification that if a member or associate or employee of the Lisa McPherson Trust turns on their heel and walks away from the process server, they are thereby in violation of the injunction. The court never said that. The court didn't intend to say that. I think it is almost a perverse misinterpretation of the court's order by the petitioner, to the same degree of perversion they accuse us of committing, to say that the court's order must be interpreted that Mr. Minton shall stand still, rock solid in place, and submit to service of process by a process server. The court did not say that, and that was not the purpose of the court's clarification of this injunction. the petitioner seems to argue that if Mr. Minton tries to maintain a 10-foot distance from a process server under the mistaken but cautious misinterpretation of the injunction, he is thereby in violation of the injunction, no question about it. And that is taking this injunction and the court's order of clarification and turning them completely on their head in one of the most amazing demonstrations of dislogic I've ever seen in a courtroom. The violation theory under Thompson, that somehow his running from Lindsay Colton is obstructing or embarrassing the court in its proper functions, just doesn't hold water. This is based on the idea that the process server is an agent of the court under the court's order of December 1. Granted, the process server is an agent of the court for making sure that any process server, no matter who hires that process server, is not subject to an injunction. That's accepted, that's acknowledged, that's very clear in the court's order. But this was not meant, this order by the court of December 1 was not meant to be a weapon to be used only by the petitioner so that they could take their process servers and intrude anywhere they wanted to, and woe be to the person who so much as looked cross-eyed at them. There may be an alternative argument here the petitioner is trying to make, and I ask the court to reject that argument. And that is based on the idea that the process server is a law enforcement officer under 843.01 and 843.02 of the Florida statutes. Well, again, I cite Weiner v. Kelly. You cannot use an injunction to enforce a criminal statute. And clearly, 843.01 and 02 is a criminal statute. If they're suggesting to you that you should hold Mr. Minton in contempt of court because somehow a process server is a law enforcement officer under Chapter 843, and that he committed the act of obstructing or opposing, well, we have another division of this court that can handle that. But this court cannot handle that as a contempt of court, and it cannot handle that as a violation of this injunction. Now, if the court were to accept their interpretation of the law, that means that every time a person refuses to answer the knock on the door from a process server, that person is guilty of a misdemeanor. The court is well aware that that is not the state of our law. I ask the court to reject these alternative theories that somehow Mr. Minton's actions constituted either a violation of the law or some contempt of court in embarrassing the court in its proper function, and to find that there is clearly no violation of the injunction. My final concern about this whole episode, my deepest concern about this whole episode involving the process server, is that the whole thing was clearly a setup. After all, the petitioner knew that the injunction was being interpreted by the respondents to extend to process servers, Clearwater police officers who were under the pay of the Church of Scientology, and that they could take advantage of this misinterpretation by Mr. Minton and by others. The petitioner was aware of the incidents involving John Merritt and Stacy Brooks, in which they strongly and verbally opposed service of process under certain circumstances, such as at the restaurant and in the corridor of the Lisa McPherson Trust Building. The petitioner knew that Mr. Minton was knowledgeable of these incidents. The petitioner knew that Mr. Minton would be arriving at the Lisa McPherson Trust Building at a particular range of time, so that the process server, Lindsay Colton, laid in wait for Mr. Minton for a period of about 45 minutes. Now, they had a video camera there. This was new too. It was something they had not done before during any prior service of process incident. But they had a video camera there to make sure that they recorded Mr. Minton's predictable adverse reaction to service of process. Then the petitioner put together a largely pointless package of paper, which should have been served pursuant to Rule 1.080 of the Florida Rules of Civil Procedure, because it did not constitute actual service of process under 1.070. They knew, the petitioner knew, that Mr. Minton had an attorney of record who would receive service of any papers that they had to serve on Mr. Minton. So they contrived this whole event in an effort to put Mr. Minton in a bad light. But the problem with what they contrived was that they were hoisted on their own petard when Miss Colton actually did her job and succeeded in serving Mr. Minton with the stack of papers that she had. There is no dispute that he was served. We are hardly in a position to contend that Mr. Minton was not served, and we admit that he was. He was served just as quickly, with just as much expedition, as if he had stood stock still on the sidewalk, given Miss Colton a big smile and a big thank you after she had served him. There is, in fact, no obstruction of this court in its proper functions in what occurred. If, to demonstrate his disgust, Mr. Minton hurls these papers to the sidewalk, he does so at his own peril. If he fails to appear for a deposition or a motion hearing, he does so at his own peril, and the court is in a position to deal with that issue at that time. But the court should not find a contempt of court occurs every time somebody scowls at papers that have been served to them. It is not indicative of a contempt of this court or anything other than what Mr. Minton said it was, which is to signal his disgust in the manner in which he was served by the petitioner. If Mr. Minton was showing his contempt for the church and not for this court, that's hardly a basis for a violation of this injunction. I would then point out that as part of this process, as part of this setup, the petitioner or the process server for the petitioner then files a questionable affidavit concerning subpoenas or referring to subpoenas, which were not even at issue in this case. And then, to top it all off, the petitioner comes in asking for an equitable remedy when their hands are dirty with the setup that they contrived in order to show that Mr. Minton somehow was violating the injunction. The petitioner should be denied its equitable remedy in this matter simply because they come into this courtroom with unclean hands. Unclean hands as a result of the setup that they imposed on Mr. Minton. Mr. Minton's history shows that he did not avoid process servers in the past, even under the most trying of circumstances, when they served him on his birthday with balloons, when they served him at dinners, when they served him by running a car under a closing garage door. Mr. Minton, under the circumstances, showed unusual grace in the acceptance of service papers in the past. In this particular instance, Mr. Minton acted in accordance with what he reasonably interpreted the injunction to mean out of an abundance of caution. He had no actual knowledge of the court's order of December 1st clarifying the injunction, but it doesn't matter if he did. The order of December 1st making process servers agents of the court did not mean that all respondents were ordered to stand still and obey all process servers as if they were obeying the court itself. The petitioner suggests that Mr. Minton should be punished for being overly cautious in his interpretation of the temporary injunction, that somehow his overcaution is a mockery of this court's injunction. I suggest to you that caution in following this injunction and insisting that others obey this injunction cannot possibly be a mockery of this court's injunction or any other order of court. Because there's no legal basis for finding this incident amounts to a contempt, there's clearly no factual basis for proof beyond a reasonable doubt on this matter. Now, in the Coachman driveway incident on January 6th, the videotape is the best evidence of this episode, and at the risk of restating what I said during my renewal of my judgment acquittal argument, I want to review the facts quickly. Mr. Minton was walking northbound on the east side of Fort Harrison in an orange zone as he approached the Coachman driveway. The videotape clearly shows that when he was more than 10 feet south of the south edge of the drive, still in an orange zone, he turned his attention to Antonio Avila, who was videotaping him. Mr. Minton, as the video shows, points the threat at Mr. Avila and warns him through a megaphone, "Stay back 10 feet, buddy." He then continues this admonition of Mr. Avila as he crosses the entire width of the driveway of the Coachman parking lot from the southern orange zone all the way up to the northern orange zone. The court would see by viewing the videotape that Mr. Minton clearly takes 4, perhaps 5 steps after he passes the north edge of the drive before he then turns his attention to the 2 men who are working on the pressure washer a few yards away, at which point, admittedly, he is arguably demonstrating, while clearly in an orange zone, 10 feet from the driveway. He shouts at the 2 men to ignore him and in fact get their pressure washer going while he goes on, clearly demonstrating they certainly weren't harassed, intimidated, or thwarted in their efforts by Mr. Minton. He obstructs no persons or vehicles while he is crossing the driveway, which, after all, was the purpose of this court's order on that particular point. When the court took its blue marker and marked off the driveway with the admonition to stay 10 feet away from the drive, it was clearly with the intent to say you can't demonstrate here and you certainly can't block the path here. Mr. Minton complied with that order of this court. He crossed the driveway with all due diligence and deliberation, and he did not block anybody in the course of crossing the drive. He did not resume his demonstrating until he was clearly 10 feet north of the driveway.
Excuse me, Your Honor, I may have misunderstood, but I was under the impression that the incident Mr. Howie is arguing now was JOB by the court.
It was, but I figured if you want to start, you can start going right back into it. It's okay with me. I'm sitting here fat, dumb, and happy. Let the record be real clear.
Your Honor, I'm sorry. I had it down as a denial.
I'll let you.
But I'll accept the...
That's all right. You want to go ahead and argue your man right into it, go ahead.
I'll move to strike what I just said.
Granted.
Thank you.
Moving on.
Concerning the Watterson Street incident, I'm sorry, it's going along so well with my argument here.
Well, you were on a roll, and I didn't want to interrupt you, but I thought, well, that's, maybe
let me dispose of my police incident while I'm at that, too.
Let that record be real clear of the professionalism and integrity on Mr. Pope's part there to help you out, Mr. Howie.
I appreciate it.
You're owing one.
I will have him do my closing argument in my next case.
Oh, okay. Give the murder case out at 49th Street. Go ahead.
Yeah. Let me talk about something a little more relevant then. The Watterson Street theft incident on January 6th. Again, the videotape is our best defense in that regard. The facts are fairly clear that Mr. Minton was in an orange zone as he shouted through the megaphone. The video camera pans away momentarily, but when it pans back onto Mr. Minton and the people accompanying him, it is clear that Mr. Minton no longer has a megaphone in his hand, and that Mr. Lerma, who did not have a megaphone in his hand previously, now has a megaphone in his hand. Mr. Lerma brings the megaphone up to his mouth and starts shouting. Now that's significant. If the court will look at the videotape, when Mr. Lerma is clearly calling out through the megaphone, the court will hear Mr. Lerma's voice and can identify Mr. Lerma's voice at that point. Now, as for Mr. Minton, holding only the 3, he crosses the Watterson Avenue in a diagonal, obviously heading towards the Lisa McPherson Trust Building. This demonstrating being done for the day. When he is, I would point out that he is north of the northern white line with the clear purpose of heading back to the Trust Building. At that point, Mr. Minton only has the 3 in his hand, and he is holding it up straight up as he walks down the western sidewalk going towards the Lisa McPherson Trust Building. Now, during this entire time, there is noise on the tape, the noise of people calling in loud, booming voices across the street. The petitioner argues in this case that this must be Mr. Minton's voice. I asked the court to look at the entire tape, including the instance where Mr. Lerma is clearly talking on the megaphone, and I believe that the court will identify this booming voice assigned to Mr. Minton as actually being the voice of Mr. Lerma speaking through the megaphone, which gives it such amplification. There is absolutely no competent evidence in this case, either from the videotape or anything else that the court heard, that says this was Mr. Minton's booming voice as he walked northbound on Watterson. There is simply no evidence of that. All that the videotape shows Mr. Minton doing is holding the 3 straight up in the air. The 3 had absolutely no words on it other than the injunction that was attached to the end of it. Clearly displaying the court's injunction, even in a non-orange zone, is not an act of demonstrating, picketing, or protesting in a non-orange zone. There is certainly no proof beyond a reasonable doubt that this act would constitute a picketing or protest in a non-orange zone. Finally, I would point out that during this entire incident, there was no other violation of the injunction. He certainly did not come within close to any member of the Church of Scientology. He clearly did not block anybody. The street was empty. He clearly did not inhibit anybody from going into or out of the building. There were no other violations of the injunction. Mr. Pope spoke of the court wasting its time in the future. I would like to think that this hearing has not been a waste of time, because in fact a lot of things have been hammered out here and some good may come of this hearing. But I think where we have wasted time in this hearing is that the petitioner has been required to prove a violation of this injunction beyond to the exclusion of a reasonable doubt, and the petitioner has failed in that effort in each and every matter that was raised in the order to show cause. Mr. Minton has demonstrated that he did not have any intent to violate this injunction, and that in fact he comported himself within the injunction with caution and will continue to do so. And for those reasons, I ask the court to find Mr. Minton not guilty on each and every one of these counts.
Okay, Mr. Howie, I thank you very much. Before we launch into the arguments by Ms. Merrick, this would be an appropriate time to take a luncheon break. I anticipate his will be at least the full 45 minutes. So if we come back at 1:15, we'll pick it up from there with the closing arguments. Thank you all very much.
All right. The court will be recessed till 1:15. Courtroom will be locked until 1 o'clock.
That's why